I'm Jameson Moreno, reporting the Amicable Settlement of Disputes.
Amicable Settlement of Disputes. Preliminaries. Katarungang Pambarangay or the Barangay Justice System is a local justice system in the Philippines. It is operated by the smallest of the local government units, the barangay, and is overseen by the barangay captain, the highest elected official of the barangay, and its executive. The barangay captain sits on the lupong tagapamayapa along with the other barangay residents, which is the committee that decides disputes and other matters. They do not constitute a court as they do not have judicial powers. The system exists to help decongest the regular courts and works mostly as alternative community-based mechanism for dispute resolution of conflicts, also described as a compulsory mediation process at the village level. Throughout the Philippines, the barangay justice system handles thousands of cases a year. Since officials have more flexibility in decision-making, including from complex evidence rules, and receive some resources from the government, the courts are the more numerous and accessible than other courts, and therefore, the courts are able to hear more cases and to respond more immediately.
Halimbawa nito ay ako ay involved sa traffic accident. Dahil sa amicable settlement, hindi na ito naging mas matrabaho at hindi na ito umabot sa korte. At dahil dito, nagkasundo kami ng magkabilang panig sa paraan kung paano mareresolba ang problema ng bawat isa.
History. There has long been a traditional local system of resolving disputes. Presidential Decree 1508 talks an unofficial, time-honored tradition of amicably settling disputes among family and barangay members at the barangay level without judicial resources. Alfredo Flores Tadyat was the principal author of the Presidential Decree 1508, the Katarungan Pambarangay Law, and he also wrote its implementing rules requiring prior conciliation as a condition for judicial recourse. For 12 years, he was a member of the Committee of Consultants, Bureau of Local Government Supervision, which oversaw the nationwide operation of the Katarungan Pambarangay Law. Under the decree, the body was known as Lupong Tagapamayapa. This decree was replaced by the Local Government Code of 1991. The Katarungan Pambarangay share characteristics with similar traditional hybrid courts in other countries such as the Solomon Island, Papua New Guinea, Nigeria, and South Africa, among others. Such courts emerged during colonial periods as Western imperial powers introduced Western legal system. The Western legal system were usually applied to Westerners, while the local dispute resolution system were integrated into the Western system in a variety of ways, including incorporation of local decision makers into the government in some way. After independence, many states faced the same problems, as their former rulers, especially limited geographical reach of state institutions. Western-modeled institutions often divorced from community structures and expectations, and resources constraints in the justice sector. Hybrid courts became a middle ground for supporting community decision-making, while simultaneously expanding the authority and reach of the states. Besides hybrid courts, other authors have described the system as a non-state justice system.
Sir, I'm going to discuss the Katarungang Pambarangay Presidential Decree 8 repealed by Republic Act 7160. Concept of barangay and lupong tagapamayapa. First, barangay. It refers not only to barrios which were declared barangays by virtue of Presidential Decree number 557 but also to barangays otherwise known as citizen assemblies pursuant to Presidential Decree number 86. Second, barangay captain. It refers to the barangay captains of the barrios which declared barangay by virtue of Presidential Decree number 557 and to the chairman of barangays otherwise known as citizen assemblies pursuant to Presidential Decree number 86. The lupong tagapamayapa shall be composed of punong barangay as chairman and 10 to 20 members. The lupon shall be constituted every 3 years. Sabi po, ang barangay daw po ay binubuo ng barangay captain at 10 to 20 members. Ayun po yung mga kagawad at mga tanod na bumubuo po sa isang barangay na nagsisilbi po sila ng 3 years. Any person actually residing or working in the barangay not otherwise expressly disqualified by law and possessing integrity, impartiality, independence of mind, sense of fairness, and reputation of probity may be appointed as a member of the lupon. A notice to constitute the lupon, which shall include the names of proposed members who have expressed their willingness to serve, shall be prepared by the punong barangay within the first 15 days from the start of his term of the office. Such notice shall be posted in 3 conspicuous places in the barangay continuously for a period of not less than 3 weeks. The punong barangay taken into consideration any opposition to the proposed appointment or any recommendation for appointment as may have been made within the period of posting shall within 10 days thereafter appoint as a member those whom he determines to be suitable therefore. Appointment shall be in written, signed by a punong barangay and attested to by the barangay secretary. The list of appointed members shall be posted in 3 conspicuous places in the barangay for the entire duration of their terms of office. In the barangay where majority of the inhabitants are members of indigenous cultural communities, local system of settling dispute through their councils of datus or elders shall be considered or recognized without prejudice to
Good day everyone, I'm Rodolfo T. Moralin III from CRIM 35.
Today, we will be talking about the roles and function of the lupon.
Roles and function of the lupon. The following are the role and function of the lupon. Number 1. Exercise administrative supervision over the conciliation panels provided herein. And next is the number 2. Meet regularly once a month to provide a forum for exchange of ideas among each member and the public on matters relevant to the amicable settlement of disputes and to enable various conciliation panel members to share with one another their observations and experiences in effecting speedy resolution of dispute. And number 3 is exercise such other powers and perform such other duties and function as may be prescribed by the law or ordinance. oath and term of the office. Upon appointment, each Lupon member shall take an oath of office before the punong barangay. He shall hold office until a new Lupon is constituted on the third year following his appointment unless sooner terminated by the resignation, transfer of residence or place of work, or withdrawal of appointment by punong barangay with the concurrence of the majority of all members of the Lupon. Secretary of the Lupon and the pangkat ng tagapagkasundo. The barangay secretary shall currently serve as a secretary of the Lupon. She shall record the result of the medication proceedings before the punong barangay and shall submit a report thereon to the proper city or municipal courts. She shall also receive and keep the records of proceedings submitted to him by the various conciliation panels. And that's all for today. This is the end of my report. Thank you for watching.
The Lupong Tagapamayapa is composed of the punong barangay as the chairman and 10 to 20 members selected every 3 years from among the barangay residents or person who is working in the barangay not otherwise disqualified by them. Qualification for Lupon Tagapamayapa. First is you have to be resident of the barangay or working in the barangay. Second is suitability for the task of conciliation. Letter A, integrity. Letter B, impartiality. Letter C, independence of mind. Letter D, sense of fairness. Letter E, reputation of probity. Letter F, other relevant qualification. Function of Lupon Tagapamayapa is or shall exercise administrative supervision over conciliation panels or pangkat tagapagkasundo. Shall meet regularly once a month to provide a forum for the exchange of ideas among its members and the public on matters relevant to the amicable settlement of disputes, and to enable various conciliation panel members to share with one another their observation and experiences in effective speedy resolution to dispute. Shall hear and decide on the withdrawal of appointment of a member of the shall enforce by execution through the punong barangay the settlement or arbitration award. Shall exercise such other powers or perform such other duties and function as may be prescribed by law or ordinances. Issuance of summons, hearing, ground for disqualification. The pangkat shall convene not later than 3 days from its constitution on the date and hour set by the Lupon chairman, to hear both parties and their witnesses, simplify issues, and explore or possibilities for amicable settlement. For this purpose, the pangkat may issue summons for personal appearance of parties and witnesses before it. In the event that a party moves to disqualify any member of the pangkat by reason of relationship, bias, interest, or any other similar grounds discovered after the constitution of the pangkat, the matter shall be resolved by the affirmative vote of the majority of the pangkat, whose decision shall be final. Should disqualification be decided upon, the resulting vacancy shall be filed.
Pangkat ng tagapagsundo. Ang pangkat ng tagapagsundo po ay binubuo ito ng 3 miyembro na nagmula sa Lupon at pinili ng mga kinauukulang partido. Ngayon, Kung nabigo ang mga partido na sumang-ayon sa mga membro ng pangkat, magkakaroon ito ng drolat na gagawin ng tagapangulo ng lupon tagapamayapa upang matukoy o malaman ang mga membro ng nasabing pangkat. So, ang ginagawa po ng isang pangkat tagapagsundo ay nagpapagitna sa barangay matapos na magsumikap ang barangay chairman o lupon chairman na pag-ayusin ang dalawang panig. Vacancies in the pangkat. Any vacancy in the pangkat shall be chosen by the parties to the dispute from among the other lupon members. Should the parties fail to agree on a common choice, the vacancy shall be filed by law to be drawn by the lupon members. Paano nga ba dapat puno ng bakante sa pangkat? Kapag nagpasya ang pangkat na alisin ang sino mang kasapi nito, dapat po magkasundo ang dalawang pangkat sa pipiliin nilang kapalit. Kapag hindi sila nagkasundo, pupunan ng tagapangulo ng lupon ang nasabing bakante sa pamamagitan ng palabunutan. Kung sakaling hindi magkasundo ang parehong panig.
Place of settling disputes. Venue. Ano nga ba ito? Barangay. Ito ay isang lugar na kung saan inaayos o inaareglo ang bawat reklamo ng nasasabing tunay na residente ng barangay na mayroon ang bawat lugar nito o municipality. Dadalhin naman sa barangay ang mga taong may pagtatalo sa pagitan nito para sa may maayos na pag-areglo ng bawat reklamo ng isa't isa. Tulad nga na nasabi dito ay maaaring dalhin sa barangay ang mga taong nagtatalo kung saan matatagpuan ang mismong lugar ng pinangyarihan nito. At ang layunin ng ating barangay ay upang maresolba ang bawat reklamo ng mga tao batay sa kanilang reklamo.
Period to arrive at a settlement. The pangkat shall arrive at the settlement or resolution of the dispute within 15 days from the day it convenes in accordance with this section. This period shall, at the discretion of the pangkat, be extendable for another period which shall not exceed 15 days except in early meritorious cases. Form of settlement. All amicable settlements shall be in writing in a language or dialect known to the parties, signed by them, and attested to by the lupon chairman or the pangkat chairman, as the case may be. When the parties to the dispute do not use the same language or dialect, the settlement shall be written in the language known to them, meaning that both parties should use the language they're comfortable speaking with or they understand fully, so that there won't be any misconception or misunderstanding whenever they process the settlement whenever they process the settlement. Conciliation, or in other words, pagkakasundo, has three main parts on the book. First is the precondition filing of complaint in court, which means no complaint, petition, action, or proceeding involving any matter within the authority of the lupon shall be filed or constituted directly in court or any other government office for adjudication. Unless there has been a confrontation between the parties before the lupon chairman or the pangkat and that no conciliation or settlement has been reached, as certified by the lupon secretary or pangkat secretary, as attested to by the lupon or pangkat chairman, or unless the settlement has been repudiated by the parties thereto. Second part of conciliation is where parties may go directly to the court. So if the conciliation did not went through or the settlement did not went through, the parties may go directly to court in the following instances. First is where the accused is under detention. Second one is where a person has otherwise been deprived of personal liberty, calling for habeas corpus proceedings, and the third one where actions are coupled with provisional remedies such as preliminary injunction, attachment, delivery, or personal property and support light, and where the action may otherwise be barred by the statute of limitations. And the third part of the conciliation, which is the conciliation among members of indigenous cultural communities. And in this part, this states that the customs and traditions of indigenous cultural communities shall be applied in settling disputes between members of the cultural communities. Arbitration. Arbitration in dispute resolution and crisis management explains arbitration as the parties may, at any stage of the proceedings, agree in writing that they shall abide by the arbitration award of the Lupon chairman or the Pangkat. Such agreement to arbitrate may be repudiated within 5 days from the date thereof of the same grounds and in accordance with the procedure hereinafter prescribed. The arbitration award shall be made after the lapse of the period of for repudiation within 10 days thereafter. And the arbitration award, same with the conciliation, shall be in writing in a language or dialect known to the parties. When the parties to the dispute does not use the same language or dialect, the award shall be written in the language known to the people. So same with the settlement, everything should be written to both parties, knowing that they appearance of parties in person. In all katarungan from barangay proceedings, the parties must appear in person without the assistance of counsel or representative, except for minors and incompetents who may be assisted by the next of kin who are not lawyers. And of course, in dispute resolution, there are effects of amicable settlements and arbitration award. The amicable settlements and the arbitrary award shall have the force and effect of the final judgment of a court upon the expiration of 10 days from the date thereof, unless the repudiation of the settlement has been made or the petition to nullify the award has been filed before the proper city or municipal court. However, this provision shall not apply to the court. This provision shall not apply to court cases settled by the Lupon under the last paragraph of Section 408 of the Code, in which case the compromise settlement agreed upon by the parties before the Lupon chairman or the Pangkat chairman shall be submitted to the court and upon approval thereof have the force and the judgment of the said court. And another part in the dispute, execution also plays a role in it. The amicable settlement or arbitration award may be enforced by execution by the Lupon within 6 months. 6 months from the date of the settlement. After the lapse of such time, the settlement may be enforced by action in the appropriate or the municipal court, and also repudiation, as of what I'm discussing earlier. Any part of the dispute may, within 10 days from the date of the settlement, repudiate the same by filing with the Lupon chairman a statement to the effect sworn to before him. Where the consent is vitiated by fraud, violence, or intimidation, such repudiation shall be sufficient basis from the issuance of the certification filing a complaint as herein above provided.